This episode is sponsored by Agent CRM. If you're in sales and tired of paying 3, 4, or 5 different companies for your email, CRM, funnels, phone, follow-up automation, check out Agent CRM. It's an all-in-one tool that combines all that you need to reach out, nurture, and close your clients. They've got weekly support calls so you can get up and running in no time. Get a free 14-day trial by going to the link below in the show notes. Hey everyone, this is Dan Wynn with the Intentional Entrepreneur Podcast. I have a very special guest and colleague with me today. He is the owner of Sabarwal Law in LA County, California. He does employment law, family law, and is on here today to discuss the top things that employers and employees should know about the workplace. So I just want to introduce to you my special friend Sanjay.
Well, Dan, thank you so much for bringing me on board. I've been a fan of yours. I believe now almost like 5+ years. I know we met you. I met you through several people that we know in common, and I've always admired. I even told you this before we got on. That I love your setup. I love how organized you are, and I really love the fact that you're doing this for entrepreneurs because there's a lot of stuff that entrepreneurs don't know about that can get themselves in trouble.
Yeah, and in the state like California, like we're in, is very pro employee, as you probably know. So it's important for advisors like us who work mainly for businesses to understand what the laws are and what they have to um, do to be in compliance with their relationship with their employees.
Definitely. I think one of the things that with one of the things with the ABC and we'll probably use some acronyms. I'll try to avoid using that in general. But California courts are basically pretty much admitted that they want to see almost everyone as an employee, which means wage and hour meal breaks, rest breaks, overtime laws can shoot up. The lawsuits are going to shoot up, and the reality is that if employers are not aware, and employees as well, if they're not aware of what their rights are, they can get themselves in trouble. And so I wanted to take this opportunity to kind of give some do's and don'ts for employers and employees, since I kind of tend to represent on both sides.
All right, so let's get into it. What are some do's and don'ts for employees and employees?
So I have this title, and this blog I just recently did, the top 10 things that employers do to get sued. And I kind of mentioned this already. They classify pretty much all employees, and I've had clients do this. They classify all employees as exempt. But what does exempt mean? It means like they put everyone as a salary. They're like, oh, that means I don't have to worry about overtime. It sounds like an easy fix. You don't have to worry about payroll taxes. I don't have to worry about overtime, meal breaks. But California has a very specific look on what is considered an exempt employee. And they go by traditional thing. It has to be someone that can make a decision on their own, doesn't need a lot of supervision. Because the reality is, if I bring someone into office and I'm telling them exactly what to do, they're not exempt. That means they're non-exempt, hourly. And this is where a lot of employers get themselves into trouble. They will either classify them as exempt or they'll make them 1099s. Both are no-nos because you want to do the analysis to make sure, am I doing this the right way? And that's where employers, number one reason they get themselves sued, they'll get a lawsuit. It'll say wage and hour violations, and the second cause of action always is misclassification, and they're hefty fines. You don't want to be in trouble for that. The other one, and I was guilty of this when we had the family business, we would let our employees take their lunch whenever they wanted. Like people had employees that wanted to take it late because they have a late breakfast. They like to eat at like 3 or 4. The problem ends up being if an hourly employee is working more than 5 hours and they don't take their lunch break, if you don't pay them a 1 hour penalty, guess what? You just violated the law. And so a lot of times employers don't understand that. That's why payroll is always talking about, when they talk about wage and hour, or when they talk about time clocks, it's not just for the overtime. It's not just to clock in and out. It's to also make sure they are taking their lunches properly. So if you have the right payroll company, ideally, most of them should be telling you, hey, by the way, there are companies, albeit I admit, that will just do whatever you tell them to do. But the good ones, and there are a few of them, will tell you, hey, by the way, you might want to do X, Y, and Z, especially for meal breaks, so you don't get yourself in trouble. So you want to make sure you get a payroll company that will at least guide you. I get that a lot of them don't want to give you HR advice, but they can at least tell you, hey, by the way, this is the law. At least do that. I already talked about being an independent contractor. I have several clients that have actually got themselves in trouble. The other one that's really, really common is not providing harassment and discrimination training to our managers. This has become a huge deal, especially in California, because of the claims of hostile work environment. The reality is, people, there's no such thing as traditional harassment. It's basically, it's not like just trying to ask a female supervisor out or employee out. It's the jokes, it's the innuendos, it's the what they call the unconscious bias, where you are promoting and only giving certain groups certain kind of benefits that you don't realize it, or you're giving raises to certain genders and not to the other. So that 2 hour training that happens every 2 years is becoming really important because it talks about all these issues. It's not just about traditional discrimination anymore. I know I'm going through a lot, so if I going too fast, tell me to slow down, because I am kind of passionate about this.
Yeah.
You
Yeah.
know, the other one is, and this reminds me of small business owners, letting employees decide, you know what, they want to work overtime, but they want to work only 6 hours, and what days they want off. The reality is, if you don't have policies in place,
Mm.
you are putting yourself basically at a disadvantage, because you're going to have some employee that you may not like, and you don't want them to make their hours. So guess what? You just not discriminated based on the fact that you're allowing others, and that really gets employers into trouble.
Mm.
The other one is, you terminate an employee who takes a leave of absence because, you know what? You told me you're pregnant. You want to take care of your sister. You want to take care of your parents. I'm a small business. I can't do it. And
Mm.
they just made the determination of terminating without really even having the conversation.
Mm.
Look, I get it. Let's assume I only have one assistant. I think me and you are very similar. We have only a few employees. So an
Mm.
employee that wants to take an extended leave, it can be a challenge.
Mm.
But if I don't sit down and talk to my assistant and say, well, here's what I can do. I can't have you be gone for 6 months or 3 months.
Mm.
Can you work remotely? Can you work a different schedule? I need to engage what we call interactive process.
Mm.
Because if I don't do that, if I just say, eh, this, I'm not going to do it, it's too much
Mm.
work, guess what? You just got it yourself into wrongful termination and disability discrimination, which can cost hundreds of thousands of dollars. And if you don't have insurance like EPLI, which 99% of small business owners don't have employment practices insurance,
Mm.
you got yourself in trouble.
Mhm.
And this is where a lot of employers make these mistakes. The other one, this is a favorite of mine. It sucks because somebody quits or you fire the employee, but if you don't, but they have your laptop. I
Mhm.
always use that example because laptops are big items. So you said to the person, you know what, you're not going to give my laptop back. I'm going to keep your final check. Guess
Mm.
what? You can't do that.
Yeah.
You have to pay the person their final check. And there has to be the day that you terminate them. If you decide to run the check to payroll because it's too, you don't want to mess with the manual check, every day you don't pay their check, it's called a waiting time penalty, which is the hourly rate times 8 hours times up to 30 days. So I had a client that owed their employee $400. And for some reason, payroll didn't just process the paycheck. They ended up paying $4,000 in penalties because every day they just didn't do the final check. So what happens? So that's somebody that is fired. What is somebody that quits? You have 72 hours to pay them. So you don't have to have the check ready for them, but you have 72 hours, not 3 business days, not till Monday. Make sure it's taken care of. The other time is if somebody gives you notice, say, I'm going to leave on the last day on, let's assume, end of this month, August 31st, is I'm out of here. You need to have their check ready. So those are the kind of things a lot of employers make mistakes on. And labor lawyers that actually are focused on only employees use those penalties to basically make really high demands, because statutorily they can make those demands. And if they if that employee files a complaint with the labor commission, they will be entitled to those penalties. Um, the
Do
other
they
one,
get do
yeah.
do 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 plaintiffs attorneys or employee attorneys, are they entitled to attorney's fees?
They are, because if they have basically use a statute, and it depends on what statute it is. So, for example, under the reality is, and if we're talking, is a lot of times they don't really care about their attorney's fees because most of these cases are done like personal injury on contingency.
Okay.
They get a
Okay.
percentage. Having said that, if it's like a wrongful termination or disability discrimination, or if it's on a Department of Fair Housing employment violation, there are attorney fees provisions in there, or it's an ADA violation. But that's not where the money's at. The reality is they know the money's in these penalties. It's on the fact that juries don't like crappy employers, because the reality is if an employer is seen to be not acting in good faith, juries can give really large awards against them, and that can be a problem. Nobody looks at good intentions. What's that saying? The road to hell is paved with good.
Very good intentions. Yeah.
I never got that until I started practicing employment. For example,
Oh,
this next example, I had a small business owner who was so like giving personal loans and then deducting the money from paychecks. California Code 224, it doesn't allow that. You're not allowed to make any unauthorized deductions from their paycheck. You have to do payroll, workers' comp, whatever is legally authorized on a paycheck, but you cannot take money out of a loan. Now, it could be a separate arrangement. I don't recommend it, but because also the problem is going to be that if you do not, get paid, and they quit, you're not allowed to. You don't have to make them be liable to that. You can't force them to give you the money back. Um, and the other one, I don't know if anyone does it anymore, is like I think some do use it or lose it vacation policies, because vacation, if it's accrued, if let's assume you give me vacation for 7 days, and there's a accrual policy that says I can accrue up to 7 days if I work for a whole year, and I end up quitting at the end of the year. Once I've earned that policy, that vacation, that's considered wages, and I have to get that paid. So when an employer says, "Well, you didn't take the vacation, and it was a vacation as discretionary, it was my discretion to give you the vacation. I don't have to pay you." Guess what? You just got yourself in trouble. So those are the ways that seems kind of subtle, but a lot of employers are really surprised to hear this, because even if they're trying to do right by an employee, these are things that can be taken on the other extreme. So that's what happens being an employer in California.
and you mentioned intentions, and a lot of these things sounds like they're statutory, so it doesn't matter what your intent is. Like if it happens, whether you had good intentions or bad intentions, you're going to get hit no matter what.
Yeah, but I meant X, Y, and Z. I meant to, yes, and then look, I get it, and I've been a small business owner, and I know Danny, you know this as well. It's fine. We want to help each other as human beings. But once there's an employer and employee relationship, if they're not taking care of making sure that things are, and let's be honest, when things are going great, it's not an issue.
No one cares.
I,
Yeah.
I tell this to my employer clients all the time. I said, look, if you're great with your employees and you treat them fairly and nicely and fairly, okay, I know it's a loaded term. If you're good with your employees, you're not really going to have an issue. It is going to be when things break down, or your manager or someone, because you fail to train your supervisor staff. Because the reality is, it's not always the owners; it's more often it's your staff, because they represent you, that get you in trouble. It's your managers that don't have the training. If you don't do the 2 hour training, if you're not spending time with them, coaching them how to talk to a difficult, what they consider to be a difficult employee, if you don't have write up procedures, if you don't tell people, here's how somebody can earn vacation. I had a client call in the other day. They were terminated, even though they had been there for 1,250 hours, which is a year, and they were entitled to take their 3 months family leave because they had to take care of a parent, and that thing was denied. And I'm like, no, you have to give them that. They've already earned the hours.
Mhm.
But because an employer didn't know, they didn't teach their manager, they could have potentially gotten themselves into trouble. Luckily, they called and I explained to them, hey, no, they have already earned it. This is called the Family Medical Leave Act. I sent them resources. And so that's the other thing I always encourage employers. Ask questions. If you
Mhm.
don't know, don't assume just because everything's been working out. Have a handbook. Your handbook ends up being um, that's your foundation, because you can then, at least if there's a lawsuit, you can say, look, when the person was hired, we went through the handbook. This is why handbooks are 60 pages long. and we give them the training. We told them exactly what the policies were. We told them what they have to do because that documentation becomes very important in a litigation. Because at that point, it's your word against theirs. And if you've had them at least sign stuff, you can at least cover yourself that way.
What are your thoughts on using professional employment organizations to kind of hedge against some of these risks of having a kind of statutory employee?
I mean, it really depends honestly on cost. It's a cost benefit analysis, right? I mean, listen, I when I first started, I did ADP or I used another big and then I couldn't afford it. I always highly encourage a lot of small business owners that find a payroll company that does HR as well. A lot of
Hmm.
them do because they charge you a little bit more for it, but they don't
Hmm.
charge you because a lot of people cannot afford to either have an in-house person. Now, yes, what you're talking about is Sherm and a couple of the organizations. They're great. The problem ends up being you need someone or some resource that you can actively look to. Now, I always recommend the California Chamber of Commerce. They're pretty business friendly, but
Hmm.
they're a great resource. And honestly, it's probably the best membership that any small business owner
Hmm.
can spend. And I'm not being sponsored by them because I tend to do, but they have great information
Hmm.
and their blogs, their forums. I mean, they have everything already thought of. They even have I believe, a handbook creator. In fact, instead, I say my client sounds kind of weird, but I didn't want to charge them because they wanted me to do the handbook, and I said, look, I'm going to charge you my hourly rate. The California Chamber already has a handbook creator. Just use their software. And
Hmm.
it costs like 100. I don't even know. I don't remember what it was, but it was ridiculously cheap. I'm like, why would you want me to spend and charge you $3,000 when you can spend a couple of hundred and get the same handbook, probably even a better handbook because they're up on the laws. They
Hmm.
they walk you through it. So I recommend. So yes, the organizations are great as long as you make sure you get the membership. Just don't go on the website and download stuff from. I have business owners. I do that too. They'll download some forms and not others because they don't. There's no context. They
Yeah.
may say, "Well, I covered my write-up policy." Well, where's your Family Medical Leave Act? Where's your paid family? There's that. So with the COVID-19, there's been a lot of confusion on what is the Paid Sick Leave Act and Dan, when we get a chance, I'll send you some stuff on that, or we can talk about it next time because it's become a really complex area of law, especially with COVID-19. And can you fire someone? Can you require tests? So those are kind of questions that you need someone who's well versed in California employment law or
Hmm.
HR to walk you through, because that's a very common mistake I see.
Yeah. Um, so I think best practice is to have maybe someone like you as an employer side attorney, constantly advising businesses. But we've all been small businesses where we can't have someone like you on retainer, but we need kind of that ongoing advice. Is the Cal Chamber, do they just provide information, or is there another resource where like maybe not quite what your level, but like something in between regarding
Yes, they do.
HR? Yeah, yeah.
In fact, I've used it's called the labor law. I think it's the highest level. I think is the it's a little pricey, but it's like it's totally worth it. I think the highest level that they offer is like I think $700 annually,
Hmm.
and out of that, there's a labor law helpline that you
Mm.
can send them a question, and there's a lawyer. Their lawyer will call you back within a couple of hours and tell you and walk you through what you need to do. Um, Obviously, you can't use it. You can't call them every day.
Yeah,
I
yeah,
guess maybe you could,
yeah.
but they're a great resource, especially when it's a very unique. Especially in fact, I've used them a little bit more for COVID-19 stuff
Mm.
myself because some of the stuff when it's very complex, you want to make sure that you're thinking the right way. Because most of employment lawyers, yes, would love to charge you, but I always struggle with this. That I'm like, I don't want to make money by just scaring you. I want to be able to make sure that you can be a successful entrepreneur without
Hmm.
always needing my feedback. I
Hmm.
think I've done my job. If you at some point know what you need to do all the time, and call me for the one-offs or the really unusual situations, because I truly do believe in good karma. That I think if you only call me when you really absolutely need me, I think, God forbid, like there's a litigation or something bigger, you're going to think of me.
Hmm.
But if you are hesitant to pick up the phone because you're like, if I call Sanjay, he's going to start running the, you know,
Yeah, yeah.
I don't want that. I hated it I used to hate it when I would call my outside counsel when we had the business. And I'm like, wait a minute, you called me, you charged me for asking you a question. You didn't even give me an answer
Yeah.
because I called you. And I'm like, to me, that never made sense.
Hmm.
I get the, being part of a firm and sometimes, but I think you have to be very, you have to be almost like almost like a mentorship with
Hmm.
especially with the entrepreneurs who are new
Right.
that don't know, because if you don't guide them, guess what's going to happen? They're either going to lose faith in the system, or they're going to feel like, okay, this person I'm not going to contact, because every time I call them they send me a huge bill and I didn't even, it didn't improve my business. Like
Hmm.
my job as an employment lawyer, if I'm dealing with entrepreneurs, is to make it in a way where it pays for itself. That advice is at least well earned.
Hmm.
That's just my opinion.
Yeah. There's one question I want to ask that's, but I want to make sure that you got through all of your top mistakes of employers.
Well, I think I covered most of them. Yeah,
Okay.
I
Yeah.
skipped. Yeah, I covered all of them.
So, you mentioned COVID-19 a couple of times, and obviously, with that has made a lot of employees remote workers,
Yes.
and some, we've heard like them actually moving out of state to work for the same employer, right? So, how does an employee moving out of state but keeping the same job? How does that affect the relationship with regards to the laws?
Well, California law looks at the fact that where the company is based. So if the company is still based in California, California law would apply. And what I tell my employer clients that they have COVID-19 questions is, if you treat this like a interactive process, that
Hmm.
I'm not saying that somebody has COVID-19 that they're disabled, but
Hmm.
if you consider it in that format, if you actually engage with the employee and ask them, well, me, I'm not so sure remote 100% works for me. Are you open to coming, a couple of weekends? You know what I mean? Like, you have to have that conversation, you know and sometimes you have to check in as an employer. Do I really want all my employees in the office? Like, what's the reason, right? Is there a good business reason? Now, I may have a good business reason that, hey, you know what, business is going down because my employees are not they're not connecting with my clients. My clients are not feeling they're feeling disconnected. I'm losing business. I need my employees to be able to go in and talk to their clients, right? If I have that kind of situation, then if I'm able to convince the employee that, look, here's why I need you to be not remote, or I'm open to considering some remote stuff, but it can't be 100% remote. But at least you're having that dialogue.
Yeah. Yeah.
I'm not a big fan of, and I know I've heard in the news there are companies that are saying, no, going September 1st, everyone's 100% remote. There's no discussion,
Hmm.
because there are exceptions, right? There are people that are, either working from home for because of health reasons. They may be immune compromised. They may be having elderly parents that they live with. They may have, siblings that are, having, they can't afford to have to be around people that are exposed to a lot of people. You need to have those conversations, because you
Hmm.
can't assume that everyone's going to be able to come back. And you definitely want to listen with an open mind. Somebody has to give you a good reason that, hey, I can't come back because of X, Y, and Z. You should then engage in them and talk to them like, well, what can you do? Here's why this is important. Can we come to an agreement? And having said all that, they are more, a lot of times a company just cannot so my assistant, let's assume she, he or she wants to work remotely, and I'm like, I'm one employee, a business owner. I can't afford for you to not be here and not greet clients.
Hmm.
Then it becomes what is called an undue burden. And if you can show that, hey, I try to accommodate, I couldn't do it, and because I couldn't do it because of undue burden, then potentially you're excused from having to, give that leave, or
Hmm. Hmm.
tell them, hey, we're going to have to part ways because I can't do it.
Yeah.
So, but it's really, really important. I'm always cautious, because I know employers want to jump to that, but
Hmm.
I'm like, you got to go through the steps. You can't just say, oh, it's an undue burden. Like,
Right.
it just doesn't work.
Yeah. I know there's some other stuff you wanted to share with
Yeah.
regards to employment law.
So the one thing, that's the fun stuff. So I have, obviously, we're in a new generation, and again, I'm not gonna make fun of them. Yeah, I don't know what generation are we? Are we like millennial? I don't even know what generation we are, but there are things that a lot of employees think that they're entitled to, but they're not. The number one thing is cell phones. Hey, they think they have a right to have the cell phone on them, that they can text, they can access social media sets from their cell phones. No, the reality is employers can't say no cell phones when you come to work. You can put them in your locker. And now obviously I can't prohibit you during before, after, or during your meal breaks.
Hmm.
But the rest of the time, put it away, and you can be fired for that. Because the reality is it's a distraction. And I don't want people, or whatever the reason is. So a lot of employees are really shocked to hear that. Oh, that's violating my First Amendment rights, and I'm like, no, it's not.
Yeah.
You don't have a First Amendment right to your cell
Yeah.
phone. So that can be a rude awakening. I've had a couple of calls about that. The other one is an interesting one, which is, well, we call it smoke break, but it's the vaping. A lot of people think they have a right to, breaks to go vape and go smoke.
Hmm.
And the reality is, us employers have to give two 10-minute rest breaks and a 1 30-minute on an 8-hour period. If you can do that in those times, great. The rest of the time is not my problem. So if you decide to take ultimate extra breaks, I could terminate you, because the reality is you're basically doing this on my time.
Hmm.
And a lot of employees are surprised to hear that,
Hmm.
because they're like, well, I should be able to take a break and smoke whenever I want.
Right.
No, if it's two 10 minutes,
Yeah.
lunch,
And
that's it.
and that's good to enforce too, to make it equal, because I know for the non-smokers, right, it's like, well, that guy's getting a break more than I get my regular breaks. Why is that? Why is he getting that?
And so like they're like there's a possession of, like, what's the word, like the generations say, it's like, um I'm blanking on the term, but I'm like, yeah, you're not entitled to that. You just can't want that just because. The other one that's it's a little harder for people to understand. So, for example, I had a client that had their front staff wanted to take. They had someone from in Mexico pass away, and they wanted to take 3 days leave to go out of the to go for the funeral. The reality is, there's no law that says there's any kind of bereavement leave in any situation. No matter, doesn't matter what the relative is. You know, it is a personal choice. Now, employers, I do recommend employers at least hear the person out and give the. But there's no legal right to a bereavement leave. You know, so you know and now there's an exception slightly. If I give bereavement leave for death of a spouse, then I must also offer that leave to someone who's a registered domestic partner. But so, because state and California federal law require that I treat everyone equally, but there's no bereavement leave law. So people are often quite shocked. And one of the things in our, if you ever do a handbook, there's generally like 10 pages of all the different leaves, and I tell people to look at that. You'll see generally there's not much for there isn't much for bereavement leave, because
Hmm.
there's no law like that. So
Yeah.
people are pretty employees are pretty shocked to hear that. you know so the other one, and this, I gave you this example earlier about vacation,
Hmm.
that I have a 2 week vacation policy for my employees, and employee has accrued it. Now, you know, what if I decided to take that during our busiest season and the holiday season? Well, even if I have accrued vacation, I can deny the vacation request based on a legitimate business need. So, because if that's not our busiest time, I cannot afford for you to then take a vacation. So, a lot of employees are really shaken up, and I've had a couple of calls saying, "Oh my God, they didn't let me take the vacation. They doesn't like me, and I should be able to sue." And I'm like, well, no, they have two choices. They can either let you accrue further, and there are employers that will let you accrue further, or they'll cash you out. Not
Hmm.
they can't take it away, but
Hmm.
they can give you the money for it, especially if you want to take it during a really busy time, or they'll tell you you can take it in January when it's slow time. So you cannot dictate to your employers when you get to take your vacation. you know so that's a tough one, because a lot of employees are really, really shocked to hear that. But it's also really important that now if a woman who has recently returned from pregnancy disability leave, she decides to take vacation, and you tell them, well, you only took too much time because you were already on leave. So be very, very careful when somebody is asking for vacation, or somebody's asking for leave for a medical reason, because it can get tricky, and you don't want to look like you are really retaliating against a person, because that can become problematic. And the other one, I mentioned it a little bit. People are a little confused about this whole paid family leave. I get some employees think that, oh, I get 8 weeks of paid family leave because I'm having a baby or whatever reason. The Paid Family Leave Act that's given by California, it's basically a wage replacement program. It's the California is requiring employees, and it's money that employees are putting in through their paychecks into this thing. So they can take the paid family leave, which is a wage replacement when they take a leave for baby bonding
Mhm.
or care for an ill family member, but it does not give them a right to take a leave. It's
Mhm.
just giving them the money to go on an unpaid leave, or take the time off, but it does not give them that they get 8 weeks protected leave. So sometimes employees are very, very confused.
Mhm.
This is where sometimes it helps to have HR department that can explain to people what is the, because a lot of the family FMLA, what we call FMLA, the baby bonding and the disability, these are all unpaid leaves. So even
Mhm.
if you accrue the time, and assuming you're the if you're a big enough employer, a lot of employees don't understand that these leaves are unpaid. So yes, I mean, our job is to basically make sure that if you take the 3 months off, you don't automatically lose your job. It's just a wage protection.
Mhm.
It's not paid. So sometimes people have to understand, yes, you get the 3 months, but it is, yes, it can be a problem if you can't afford to take off the 3 months, but that's not an
Mhm.
employer's problem, right?
Right.
Which is
Right.
why
Right.
they'll give you the paid family. It's a brochure that we give to our employees, and we'll tell them, hey, you've already paid into this, assuming they've worked there for a year. They should
Mhm.
have enough in there. And generally, it covers disability, I believe, covers, I think, 55%. So
Mhm.
it's not like no one's going to get rich off of it. And it really
Right.
is designed to be, uh, afford the employee to be able to transition and be able to take care of whatever they need to that's, causing the harm.
Yeah,
But
I
there's a lot
know.
of, go ahead, go ahead.
Slight twist on the topic is, as I remember as a business owner, um, uh, I think I was offered it. I remember checking some box as a business owner, like you get the state, whatever the state is, paid family leave, but I didn't pay into it
Oh,
past year, so I wasn't eligible to it. But it's one of those, you don't know what you don't know, especially
yeah.
if you're not an employer or attorney, like you don't know what to do. So, but it's interesting to me is like, oh, as a business owner, right? As not set up to as a corporate employee, but as a business owner, I would have needed to pay into that in order to get it when my son was born.
Well, and it's really important because like they'll ask you to, and this is where sometimes I feel like you have a great opportunity if you have an HR department, or you have a right HR company that when they're onboarding the employee, they're explaining, obviously I get it as a business owner, you're busy. You definitely want to have the right people who can at least say, hey, here's the different, and I get it. People don't understand, which is why you need to at least offer a resource for people to go and ask questions because that's where a lot of confusion is also where people aren't just they don't know about like how do I deductions, they don't know about direct deposit, they don't understand. you know I have employers that was my actually, thanks for reminding me. The other biggest mistake a lot of people make is on paychecks is there's like 12 pieces of information that needs to go on a check, and a payroll company knows that. But if you are just writing personal checks as a small business owner, guess what, you're in violation, even though you're like, well, I paid the person. Well, what did you deduct for whatever the deductions are, right? Is your corporate name on there? And a lot of people getting themselves in trouble on silly technical violations like that, which is problematic.
And I knew someone who got paid by basically handwritten check. I mean, they were
Yeah,
printed, but they signed it. And
right.
it's like, how come they don't do direct deposit? It's like one is a waste of your, I think it's a waste of your time signing all these checks. Two, like there's some huge compliance issues. So you miss all this that through this manual process. That's on you.
Well, a lot of them want to. I hate to say, I have small business clients that like to use their CPA, and the CPA firms offer this benefit. A lot of them don't understand it because CPAs, yes, they can also do your EIN, they can do your formation, and I struggle with this with entrepreneurial clients because CPA somehow people don't understand. So CPA can give you tax advice, right?
Mm-hmm.
More often than not, they bleed. Some can bleed into legal advice and not realize it. So when they
Mm-hmm.
start advising you on what entity you need to be, or
Mm-hmm.
I'll take care of your payroll, because to them it's like, oh, I can do the accounting. No, there are certain things you need to be aware of. So CPA firms don't know either, right?
Mm-hmm.
And as an entrepreneur, a lot of us, I'll be honest with you, I didn't even know in the beginning. difference between a bookkeeper and a CPA. I'm like, well, why do I need a? Because CPAs are obviously, we all look at the money, right? You're like, oh my
Right.
God, you charge how much?
Yeah.
I can do this on my own. I don't need
Yeah.
you. And I realized, yeah, maybe that's not a good thing. You need to have the
Yeah.
right.
Yeah. Hey, we're here with Sanjay Sabarwal, employment law extraordinaire. Lots of good information here, and we can probably spend all day talking about employment law.
Let's hope
Um,
not. Let's not.
yeah, let's hope not. And if both of us have done our job right, like you said, then they're only contacting us when there's a huge issue. So I do want to wrap this up with rapid fire questions as an entrepreneur. So all you have to do is just think of the first thing that pops in your head.
All right.
All right, you ready?
I'm ready.
All right, who do you look up to?
My mom,
Mom. All right,
first mentor.
what's the best business advice you've ever received?
Listen to your mentors. People have already done this before. Have a mentor. Number one advice:
Mm,
have a mentor by far.
yeah. What's the best business book you ever read?
Think and Grow Rich is the one. I'm sure everyone's heard of it. And the other one that I'm reading right now, which is probably not a business book, but the Four Agreements. I read
Mhm.
it annually. It's a great reminder.
Okay. If you could do one thing over again, what would it be?
One thing, one thing I could do over again. That's it. I don't know. Honestly, this is gonna sound like I don't know. I don't regret any of my failures. In fact, a lot of my failures got me where I'm at now. I
Hmm.
don't know if Dan, I don't know if you knew, I used to be a party promoter. When I graduated from law school, I
Yep.
decided I wanted to start my own record label. And I told my parents, I'm not going to practice law. So I was a concert promoter and
Hmm.
I promoted some of the biggest Indian acts in the world who I'm still in touch with. And that has given me a network of people. I've gotten a ton of business and I would have never imagined it. So, yeah, I don't think I would do anything over again. You never know.
How disappointed were your Asian parents when you told them that you wanted to be a party promoter?
They already accepted when I told them I was going to be. I told them I was going to be an English major when I went to UCLA, and they're like, they looked at me all confused, like, "What do you mean English? What are you gonna do? You speak English." My parents were pretty chill that way. You know what? I'm
Yeah.
pretty admirable. They were not traditional, but I think they were also first generation. I mean, we grew up in North Long Beach. My parents moved to Long Beach because they thought it was the beach, but I went to Jordan High School, which was not the best area.
Yeah.
So my parents had to struggle, and so I think they were just happy that we all. I have never heard the parent no from my parents.
Mm.
That was probably the most humbling thing. Never heard no.
Have you heard of the concept 3 feet from gold?
No.
Okay, so the story goes, this prospector, he buys all the equipment because he wants to go out to the west and make his riches mining for gold. So he buys all the equipment, digs for such a long time. He doesn't hit anything. Finally, he gives up. He sells it to the next guy, right? The land and the equipment. And that guy only digs 3 feet before he hits gold. So the question is, how do you know when you're 3 feet from gold, or how do you know when to pivot in your business?
Oh, that's the question. You have to have the right people around you who will tell you to keep going. I maybe I'll use an example. I do CrossFit. I'm like the worst, probably the worst CrossFitter. But the group that's there gets me to keep going back,
Mhm.
and so I think it ends up coming around like who are the people around me and are they always encouraging me. I think the theme would be I don't have a lot of naysayers in my life. Now there are people that will tell me, hey, you're not using the right tool. So that's where I think it's change. Have the
All
right
right.
tools and have the right people.
All right. And the final question is, what's the biggest challenge in your business today?
It's kind of like explaining to a lot of my small business clients all the different variations, and sometimes clients are worried that I'm trying to upsell them. And I think they have a hard time believing that no, I'm actually really wanting to be a mentor. I keep using that word because that's how I grew up. I truly believe if somebody calls me, I'm not trying to sit there and make money off of you. So the challenge ends up being that, hey, I'm not trying to upsell you anything. Here's what I think you need to do, and here's why. And yes, it's going to cost X, Y, and Z, but this is why it's important to do it that
All right. Thank you so much, Sanjay Sabarwal, for your time. Hey, if we want to reach out to you, what's the best way to get in contact?
Oh, my email's Sanjay at sabarwallaw.com. And then we're active on Instagram, pretty active. So Sabarwal, which is Instagram slash Sabarwal Law. And my blog, sanjaysabarwal.com. So,
All right. So I'll put all those links in the show notes. Hey, thank you so much for your time. And I'm sure we'll be chatting again soon.
for sure. Awesome.
All right.